Right, thanks for coming. It's an awesome turnout, and can I just say, what a fantastic location. Beautiful, isn't it? Any of you lawyers here? Good, because I hate lawyers. I had I had 7 at one event, didn't we? 7 lawyers. They thought it was funny to invite them along, and I hate lawyers because if they were always right, you wouldn't need 2 in an argument, would you? So, get on your phones and Google the Samaritans, because I can promise you by the end of this you'll need them, and they get very busy. This is about compliance and the Renters' Rights Bill. So if I do say anything funny, laugh. Because last time I had an audience this size, no one laughed, and it ruined the funeral. Right. So, this is who we are. You might know CJ Holt, but you might not know that we've also got 16 other brands. Did anyone know that? Now, this is really important. This isn't us showing off, because it's not the point. The point is, we are the biggest letting agent in the UK. The second biggest manages about 40,000 properties. We manage 152,000 properties. And the reason that I'm telling you this is because we can't afford to screw this up. This Renters' Rights Bill, we've got to get it right or we're screwed, aren't we? So we are the biggest agent in the UK by some country mile. And CJ Holt are one of the jewels in our crown. We also own Belvoir, Hunters, Newton, Fallowell, Martin & Co, Northwood, YouMove, Whitegate. It's huge. Okay? So my brands are the ones on the bottom. These are the ones I look after. And I'm very proud to represent CJ Holt tonight, and I'm grateful to be invited. Any of you clever people know what that is? Sorry? I love educated audiences. I didn't get many responses in Rochdale. Sorry, I shouldn't say that, should I? So, sorry, Lucy's my moral compass, and she just shakes her head. In fact, when I did the company conference, even the CEO puts his head in his hands. What was in Pandora's box? Now is that you? And when it was opened, what escaped? No, hope was all the evils of the world. And that's kind of where we are with the Renters' Rights. And I've got to be very careful what I say, because I did have a formal complaint from a certain housing charity recently. So we're going to just call them by the S word. I'll let you guess who it is. Oh dear. Polly Neat is just retiring from Shelter. Shelter are very good at exaggerating, all right? I mean, they put out a press release in January saying an agent had evicted a tenant 5 days before Christmas. They haven't. They just said we want the property back in February, but had to give them 2 months' notice. That, to me, is misinformation. So, I know what I was going to tell you. Has anyone Googled the Renters' Rights Bill? Because if you do, stop immediately. Google is a wonderful tool, but it works based upon keywords, keyword density, keyword relevance. You won't necessarily get the right answer. And there is a lot of information out there that is wrong. So if you listen to me, not only will I tell you what's in the bill, I'll tell you ways around it. And I'm not a great believer. I mean, the internet is awesome, but it's not always right, as Abraham Lincoln said. You're meant to read the slides and laugh, not get me to read them to you. So, what gives me the right to stand up here and talk to you guys? Well, this is what I do. I'm a member of the Letting Industry Council, which is awesome. Shelter are on it. They don't talk to me. Yesterday, I was at the Lettings Advisory Board in London and in Pont de la Tour afterwards until about 12:15, just to network. I'm chair of the Property Redress Scheme, the Ministry of Housing, Communities, Local Government Advisory Panel, and Trading Standards panel member. Now, the reason I'm telling you that is because I hear things that other people don't. Okay? I get to talk to their lordships. I get to talk to MPs, even though, in fairness, most of them do avoid me. Especially, anyone know the name of the housing minister? All right, it's Matthew Penny Cook. I emphasise that because I did call him a slight variation on that. Quite accidentally. Hello, Mr. Penny Cook. Oh, no. He lives just down the road from me, and he walks really fast when he sees me. Trading Standards. I did make a complaint about James Monroe, the head of Trading Standards, and the only person I could report him to was himself. And he has no idea what to do with this complaint. Who can investigate it? No one. Right. Most of you will know a little bit about the Renters' Rights Bill. Would you say? You know a bit about it? Good. And I want challenges. I want you to ask me questions, and I want you to challenge me. Who's worried about the loss of Section 21? Thank you. Does anyone not know what Section 21 is? Brilliant. I like that. Section 21 of the Housing Act is simply a notice that the landlord requires possession of their property back. That's it. And it's a myth that it's an eviction notice. It isn't. If you have a fixed term tenancy of 12 months, guess what? You have to serve Section 21, even if the tenant doesn't want to renew. You should serve it. Is that an eviction? No, of course it isn't. How much notice does your tenant have to give you to end a fixed term tenancy? I love this phrase, which is why I'm going to mention it, because I won't be able to use it much longer. No notice at all, because a tenancy agreement expires with the natural effluxion of time. All right? It's a fixed term, why should they give notice? They don't have to. You can have it as a contractual term, but you can't enforce it. Anyway, all this is irrelevant. We've been through this in Scotland. Okay, 2017, we went through their equivalent of the Renters' Rights Bill. So there will be no more Section 21 notices. You can't serve them once this law becomes enacted. However, just so you know, if you serve the notice the day before it becomes enacted, that notice is still valid. Okay? We're already getting tenants phoning us up saying, you've issued me Section 21, that's illegal. So you won't be able to serve it from enactment. There will be no more fixed terms. Are you aware of that? Okay, so if you've got a tenancy starting today that's for 2 years, when the bill is enacted, it's not for 2 years, it's forever. All right? No fixed terms. And anything in your tenancy agreement that says otherwise is null and void. So tenancies would be for life, but there are more grounds to get possession. All right, so it's not a problem. I'm going to tell you the bad stuff, and then I'm going to introduce you to the lovely solution. If you do something wrong, contrary to the bill, you'll be fined up to £7,000 for the first offence, then up to £40,000 for the second and third and fourth. Does anyone in here self-manage? All right, we'll see how that goes. You can leave now. Get out. There's also rent repayment orders, which are now 2 years of refunding rent to a tenant if you're in breach of something serious. Okay? That's really bad, isn't it? 2 years refunding rent. And there's no prospect of a fixed term. So even if your tenant comes up to you and says, I've got a 1-year contract as a job, can you give me a 12-month fixed term? If you do, £7,000 fine. Madness, isn't it? However, there's no point. Resistance is futile. Has anyone ever served Section 21 and then gone to court? Yeah, you must have done. When you go to court, the lovely judge will ask you for a series of documents from guest safety records, EPCs, EICRs. There's a whole range of things you have to give them. It's actually page 20 of Form N5B. I don't get out much. None of these things will you have to prove to a court anymore. That makes your lives a lot easier. The only thing you'll have to prove is that you've protected the deposit in a timely fashion. So all those are gone. Okay, I don't expect you to be able to read them, but they are on the government website on Form N5B, page 20. Restrictions. Anything that requires you to have an AST is null and void. Some of you might have mortgages that say you must let a property on an assured short tenancy, but you can't, because there aren't any. They will cease to exist. Anything that says the property must be handed back in vacant possession is invalid. Right? Does anyone here ever do rent to rent? Good, don't. Because any of these rent to rent companies, I promise you, it's going to be a problem because they won't have grounds to get the property back. Does anyone here own a property in a limited company? I'm going to tell you the perils of tax evasion later. But I can help, I have a solution. Now, this is the thing that shocks people the most. You cannot take rent in advance of more than 1 month. Does anyone here rent to students? Okay, because students very often will pay a year up front, or their parents will pay a year up front, or they'll pay up front in line with their student loans. Only 1 month in advance maximum. And this is the shocker. You cannot take 1 month up front until after the tenancy agreement is executed. What that means in law, well, I'm not a lawyer, but it's a fact. If the tenancy agreement is executed and the tenant refused to give you the 1 month's rent, you can't stop them from moving in. You look shocked. We have a solution to this, but that is what the law says. Okay? As soon as that agreement is executed, they have rights from the start date of the tenancy to the keys, even if they haven't paid you. Couldn't make it up, could you? If you've accepted rent in advance now, and the bill comes in, let's say tomorrow, you won't have to give it back. Okay, that's a bit of a myth put about by the Daily Mail, actually. Any questions on advance rent?
Yeah. If, I've only had one in the industry, but somebody with a CCJ, for example, we required at that time, which is about 5 years ago,
Yeah.
pay 3 or 4 months rent upfront.
They can't.
So we can't do that.
No.
So basically, anybody with a guarantor will go from
Well, they can have a guarantor.
yeah.
Just because they've got a CCJ doesn't automatically rule them out. And there are companies out there that will be a UK-based guarantor. And you've raised a really good point, and we'll come on to students in a minute, because I think this is tacit discrimination. So, tenant notices going forwards, again, a little bit of a myth. A tenant can give notice on the first day of the tenancy. And this is something I actually agree with. We've had landlords, or I've come across landlords in the past, who have said to a tenant, yeah, we'll do this, that and the other. The tenant gets there and the property's disgusting, and the landlord hasn't done anything. Why should the tenant be bound by that tenancy agreement? Okay, it's not fair. So I agree with this, but if the tenant gives notice on the first day of the tenancy, it doesn't actually take effect until effectively 3 months. Because the notice served on day 1 will only be effective from the next period of rental. Okay? So month 1's already started, so the notice will take effect from the start of month 2 and expire at the end of month 3. So you're going to get 3 months. Does that make sense to you? So it's 2 months, but it must expire at the end of the rental period. All right? So you're going to get a minimum 3-month tenancy. And let me tell you, in Scotland, it didn't happen. People don't move out sooner. In fact, they stay longer. And that's what you will find. I love this. The means of notice cannot be specified. I can't say it has to be in a letter. It could be an email, it could be WhatsApp, it could be Facebook, it could be anything. However, you can specify to whom the notice is served. You can say landlord or agent, but you can't tell them how they have to serve it. Now, this is a good thing, and this is one of Eric's top tips. Notice from one tenant is binding upon all tenants. So if you've got 3 people living in a property, and you go round, look at the one who's poorest, and say, hey, listen, it's 500 quid, bugger off. And if they give notice, that ends the tenancy. How good's that? Is it legal? Yes.
Is that in relation to the context of student rents?
It could be.
Okay.
It could be. We'll come on to students, but yes, it could be. But we get more than one situation where people will cohabit. So going forwards, are you familiar with Section 8 grounds? So Section 8 of Schedule 2 of the 1988 Housing Act are the grounds under which you can get possession of your property. 8 of these grounds are mandatory, where the judge has to grant possession. Even the most miserable judge has to grant possession. And the other grounds, you're not a judge, are you, sir? The other grounds are discretionary, and sometimes we join them together. One bit of advice, never serve Section 8 notice yourself, because even one word out of place, one letter, punctuation, will invalidate it. Always go to a lawyer. Why? Because they've got insurance, and we've got a solution to this as well. Most notice periods have now lengthened, as we will find out. So most no-fault grounds are 4 months. Things like breach of contract. 4 weeks now for rent arrears. It used to be 2 weeks. Going forward, you'll have to give your tenant 4 weeks' notice if they're in arrears. How far in arrears do they have to be before you serve notice?
2 months.
Who said that?
2 months.
You're right, at the moment, but it's going to change. ASB, antisocial behaviour, nothing's going to change on that. The court will grant you possession for antisocial behaviour, particularly domestic violence, and quite right too, but it's going to be harder to prove. At the moment, if you have an antisocial behaviour issue, what do? You send me Section 21 because it's easy. But going forward, you'll have to prove it, which means you'll have to get probably witness statements. I worked in East London for 11 years. Good luck with getting people to grass. So with rent arrears, we're now up to 4 weeks' notice. Grounds 10 and 11. Now, 10 and 11, these are the grounds where the tenant was in arrears when the notice was served and that they were regularly in arrears. The fundamental ground is ground 8, mandatory ground. But now they have to be 3 months in arrears, not 2. And to make it worse, you then have to give 4 weeks' notice. I don't have to tell you, lovely people, that's 4 months before you can apply to a court. And it's going to take you another 7 months before you get possession. We have a solution to this at Ellison Co. Sorry? CJ Hart and Ellison Co. How dare you dismiss Ellison Co. like that? There was a proposal for tenants in repeated arrears, but that's been ditched. Michael Gove actually agreed to that, but Mad Angela Rayner won't. So 4 months of arrears before you can apply to a court for possession of your property. Does anyone here have rent and legal protection? You will have by the end of this, because without it, you are exposed. Okay? You're looking at a year without rent before you get your property back. Now, this is important. You know there are grounds where you can get your property back if you want to sell it or you want to let it to a close family member. So ground 1 is letting to a close family member. And in a slightly J.K. Rowling Harry Potter theme, the government have defined close family members and actually say half-bloods. I am not joking, half-bloods are close family members. They don't have to be princes, but they can be half-bloods. So you can tell your tenant under ground 1, I'm ever so sorry, I'm going to give you 4 months' notice because I need the property back for my daughter, cousin, uncle, mother, anyone. All right? Now, the good thing here is you can serve that notice, bearing in mind the tenant is entitled to a 12-month tenancy. But you can serve it a month late. And if the tenant's already been in there 6 months, you can serve it sooner, because that 6 months will count towards the total 12 months. Does that make sense? Now, if you want to sell the property, that's fine too. You can serve them 4 months' notice that you intend to sell the property. And the disadvantage is, on expiry of that notice, you cannot re-let that property for 12 months. All right? And they will find out, because they will be monitoring different websites. However, if you go to the property and say to your tenant, listen, I want to sell the property because I need the cash, but I don't want to serve a notice on you because it sounds really cruel. So how about I give you a couple of grand and you bugger off? And they do. You can relet it straight away, because the 12-month moratorium only comes into effect upon the expiry of the notice. So Eric's top tip is, don't serve notice. Just tell them to go. And if they agree, your problem is solved. Do you like the sound of that? Again, 4-month notice period. If you do try and play the system, you'll get fined £7,000. And I was actually in Rightmove head office when Trading Standards phoned up and actually asked whether this property had been advertised, and for different reasons, but they will be doing that as well. The only downside, madam, if you're a limited company landlord, you can't use grounds 1 and 2, because you can sell it, but you can't let it to a close family member, because companies don't have close family. Simple as that, even if you're a director. So any questions on that? Yes, ma'am.
I could foresee a problem because...
Just the one?
Well, no, I'll start with section 1. Rayner had already stated before the general election that she would be instructing the courts to do a hardship test when landlords request a ground plan. And what is already happening is that if a landlord wants to move back into the property, if they've been working overseas or in the service of overseas, the judges are now telling you, God, sorry, I'm not having your property, use the rent to rent yourselves in.
So, whatever the lovely Angela said doesn't matter, because it isn't written in law. And judges, it's ground 1, so it is a mandatory ground, they can't refuse possession. Under the new ground 1, they can't do it.
So she cannot introduce a hardship test?
No. Not as the law is written. It doesn't allow for that. There are hardship tests, which we'll come on to, but not for selling. It's a mandatory ground for possession. So the answer to that is no. Going forward, you will only be able to increase your rent using a Section 13 notice, which is on the government website. It's Form 4A. We will do it for you if you want us to, for a very modest fee, I should imagine. But you have to do it properly. This is the only way. At the moment, in a statutory period, you have to use Section 13 in a contractual, you must not. Going forward, this will be the only way you can increase rent. Limited to once per year. Eric's top tip, don't phone your tenant up and say, I want an extra £400 a month. And he goes, oh, I can't afford that, can you do 200? And you go, yeah. Then you fill out the form and he appeals it anyway. So.
Can you build indexation
No.
increases?
No. Why would you want to? I mean, we have a rent review clause in our current ASTs, which is only there to prevent a contract becoming statutory periodic. You can put rents up however much you like. But no, going forward it will be market rate. So you would go for the full market rate. Once you serve the notice, you can agree to a lesser amount, but the tenant has the right to appeal. And he can appeal to the first tier tribunal, and the appeal is free. For you it isn't, because you've got to get somebody to represent you, which we can do for a fee. But we're cheaper than you guys. But my point is, no, rent review clause is out.
How about for
ASTs where they currently...
There won't be any ASTs. ASTs will cease to exist. Statute overrides contract. So anything that is an AST at the moment will cease to exist. And we'll come on to that again. You've been picking my slides. So the tribunal will set the new rents. As it stands, they can set a rent higher than the amount you've asked. Going forwards, they can't. They can add, under hardship, they can give the tenant an extra 2 months before it takes effect. And you won't be able to increase the rent again for 12 months from the date of the hearing, not 12 months from the date of the notice. It isn't rent control, it's rent suppression. And these increases will take you at least 7 months to be heard by the first tier tribunal. Does anyone have any questions on rent increases? You don't need to remember all this because that's what we're here for. Has anyone been to any other landlord events? And I know the answer to that because no one else is doing them. Student tenancies. You said you rented to students? Did? What have you done with them? You know, we've got one office who's selling all their student properties off to professionals because of the problems associated. They're not exempted from the Renters' Rights Bill. There's a new ground for a prior notice ground which you can put in a contract to tell the tenants that you might reclaim possession, but only if it's an HMO student tenancy. The notice will expire between June the 1st and September the 30th, and it has to be in the tenancy agreement, and more so, if you sign the tenancy agreement more than 6 months before commencement, then that clause will be invalid. And it can't be used if the student is sharing with one other person. It has to be an HMO. I won't dwell on this because no one here has got student properties, but just so you know, they're probably not something... In Oxford, as I said, it's a nightmare at the moment. Written terms. What does that mean? Well, I can honestly tell you, we don't know. The government haven't told us. We think it's going to be what they did in Wales, which is a document explaining to the tenant what is going to change in their tenancy. Okay. In Wales, they created a model version of written terms. Fantastic, it saved me a job. Until the day before it became law, and they said, oh, by the way, you can't use that. Right, why? Because it's got to apply to your tenancy agreement, not a general document. But we're already getting ready for the written terms. We've already drafted the new tenancy agreements, new terms of business. We're well ahead of the game here. I spoke to an agent where I live who said, I don't know why you're worried about it, it'll never happen. Yes, right. So we are ready to rock and roll. If you don't provide written terms before the tenancy starts, or within a month of an existing tenancy converting, you will get a £7,000 fine. Scary, mate. That's why we're here. You still want to self-manage? And a rent repayment order to boot? Rent bidding. Has anyone read about this in the press, about rental bidding? I will get a bit hot under the collar with this. So, it's a ridiculous... I changed the word for nonsense, by the way. You can't accept more than the price your property is being advertised for. Now, here's the dilemma. Have a think about this. In law, I have to phone you up with any offers I receive, regardless. But if it's above the asking price, I've got to say to you, I've got good news and bad news. I've got you a higher offer than you were looking for, but you can't take it. Do you remember Bullseye? Yeah. Look at what you could have won. I got told yesterday that that was the worst Yorkshire accent that Carrie had ever heard. At least I think that's what she said. I couldn't understand it. So it's ridiculous. We've got to specify the rent in an advert. Well, we've been doing that since 2008 under consumer protection regulations. I mean, who are these government people? Honestly, you can't imagine. I went to a meeting. Has anyone heard of the regulation of property agents? Okay. It's called ROPA, Regulation of Property Agents, and it's been championed by Lord Best. And I asked a government minister in the Housing Office, what's happening with ROPA? And his erudite reply was, what's ROPA? This is a government minister. So you can't accept more than the asking price for rent. So what do you erudite, lovely people, who I call customers, what do you think is going to happen to rents as a result? You're going to put them up, aren't you? And then see what you get. I mean, it's bloody stupid. But anyway, again, financial penalty of up to £7,000, rent repayment laws, all sorts. And who do you think is responsible for tenants outbidding tenants?
Landlord.
Tenants are responsible, aren't they? Okay? They outbid each other. We don't do it. We're happy with the advertised rents. So, just a thought. Who's worried about pets in lets?
Yeah.
Good. What if I told you you don't need to be? Do you know what the new law says about pets? No. The Daily Mail, when the Renters' Rights Bill was announced, said landlords forced to have pets. What rubbish. You are not forced to have pets. It is a blatant lie. Can anyone think of a reason why you wouldn't have a pet?
Damage.
Now that is a stick with allergies. Okay, really important to stick with allergies. I suffered anaphylactic shock twice because of a cat. And my ex-wife, Voldemort, had a cat. And I'm convinced she used to put it on my pillow when I was out. I got rid of it. And then I got rid of the cat. So, you can advertise a property as unsuitable for pets. And this works with children as well. I'm serious. If I owned a little cottage in this beautiful land with a small garden, and at the end of it is a fast-flowing stream, would I in good conscience let a single mum with 2 toddlers? No, I wouldn't. And in fact, under material information disclosure, I would have to tell the tenant it was dangerous. Okay? So with pets, I don't want a Rottweiler in a 1-bedroom flat on the 4th floor of a building. It's unsuitable. Okay? I don't think it's fair to ban people from having a goldfish, but I do think it's unfair to tell tenants they can have a pet when it's clearly not suitable. Very thin walls, neighbours. So as long as you've considered a pet and you've been shown to consider it, you are well within your rights to make an excuse. Does that make sense to you all? You are not forced to do anything but stick with allergies. I love that one.
Does it have to be a tangible reason like that, or can it be something, can you just make the choice yourself?
Are you allergic to pets? So you admit to lying?
Yeah.
It has to be justifiable. Now the reality is, what I would do, you taking my name.
I am.
Don't tell him, Pipe. So,
Excuse me, could you just repeat the questions? Because with the noise coming in from the bar, we can't hear everything that's said at the front.
yes, this lady asked whether it has to be a tangible reason,
Okay.
and I said it has to be justifiable and reasonable. And then she admitted to telling fibs. So, you have to be seen to consider it, and any reason you give has to be fair. Now, what I would say to you is, and another Eric top tip here, if your tenant says to you, can I have a small dog? Say yes. All right? If it's all right within your property and it's not a top floor flat, say no, it's fine. But you have to have pet damage insurance. I keep missing out the word damage, and it sort of implies that if Tiddles gets run over, we'll fix it. We won't. Oh yeah, pet damage insurance. Just agree that your tenant. I met a chap at, oh God, I think it was Rochdale, somewhere. He reckoned this dog had cost him 20,000 quid in damage. Right. Had you just said, I'll have the dog if you have insurance, he wouldn't have had a problem, would he? And if you say to someone, no, you can't have a dog, I refuse, and they get one anyway, what will you do about it? There's nothing you can do. We had a woman recently who went to court over, she had a cat, and the franchisee wanted to get rid of her. And she said, I haven't got a cat. We said, yes, you have. It was lying in your lounge. She said, it's a stray. It's adopted me. There's no way the judge is going to give possession. So talk to your tenants. If someone wants a pet, interview the pet. All right? It doesn't matter. If you're happy, they'll probably be happy. But if you do take out insurance, you pay for it, because otherwise the tenant's going to cancel it, aren't they? You pay for it and pass on the cost to the tenant. Does that sound fair? And in fact, the Tenant Fees Act of 2019 is being amended to allow you to insist upon a tenant paying pet damage insurance. Of course.
You said it's a small dog. I think we should specify, weight range. Because, small might be.
It's subjective, I agree.
So there's that. And so maybe even specifying the microchip number.
Well, you could. It could well be due diligence. My view on this is just take out pet damage insurance and you're covered. You might even get...
They might say it's not my dog, it's my mate's dog. But if you nail it with a microchip number.
Yeah, that's a good idea. I'll think about that. Is there general data protection regulations for dogs? General dog protection regulations? So, as I said, once a tenancy is granted, if you don't let them have a pet and they get one anyway, you're screwed. So I just think you should keep it above board from day one.
Can I just ask, sorry, while we're still on the pet side of things,
Right.
okay, so we've got the damage covered.
Yeah.
But what about perhaps the steam cleaning for the next tenant who may have allergies to a cat or a dog, but just the regular shampoo isn't necessarily going to sort out?
You can specify that. This is all part of pet damage insurance. So, yes, you could probably do that. Or my view is it's better to just be up front with these things than let them smuggle a dog in at a later date. If your current insurance policy says no pets, that will remain valid until expiry, and then on renewal that clause will cease to exist. All right? So you can't use that as an excuse. However, what you can do, anyone here got leasehold properties? You have. Your head lease may say no pets. That is acceptable because the leasehold is outside the 1988 Housing Act, so that's fine. If your head lease forbids it, you can respect that. Is that good? Good. And now you're thinking, why was I listening? Do you know you've all got to join a landlord redress scheme? All of you. If you own a property in a husband's name, wife's name, joint names, limited company, you have to join it 4 times. Okay? It has to be joined for each legal entity. Now, I think this is ridiculous, and how long is it going to take to set up? But, unfortunately, this is the law. Can we help you with this? As the regulations are written, no, but I suspect we'll be able to do it anyway. Okay? So you'll have to join a redress scheme. You'll have to be a member before you start marketing. There may be more than one scheme. As it stands, it's going to be the Housing Ombudsman. Again, 7 grand fines rising to 40,000 if you don't comply, and they have a power to expel you from renting a property. Yes, sir.
So, I've got a property, I'm the owner,
Mm-hmm.
and I'm using a letting agent,
Doesn't matter.
and the letting agent,
He's a member of a redress scheme.
yes. Does that mean I have to be as well?
Yes. In fact, a little stroke of inspirational genius there, because when this was announced, we tried very hard to convince governments that if you were using a managing agent, you wouldn't have to join a redress scheme, and they said bugger off. Landlords still have to join. And I asked one of the ministers, what happened? Who does the tenant complain to? One or both? He said, I'm sure they'll work together. Well, I'm chair of the property redress scheme, and I can assure you they won't. It's a muddle. But if you would forgive me, I don't make the law, I report it. And you're also going to have a private rented sector database. Okay? Yes, madam.
Can I just go back to the is that applicable to those that have lodgers, or is that close to an Airbnb?
Oh, what a great question that very few people would be able to answer. Unfortunately, with the Renters' Rights Bill, Airbnbs still fall under it. Okay?
And if the Airbnb is done under the rent and room scheme?
Under what?
Under the rent and room scheme.
If it's outside the Housing Act, the answer would depend on the type of tenancy you have at the moment.
My daughter lives in one of my rental flats, doesn't pay rent, and she is a family occupier of one agreement. And we're looking to do the second bedroom for full deeds.
If it's done under a licence, the answer is you'll be exempt. But to be under a licence, you need to provide a service, like cleaning the property, servicing it. So the trouble is, a lot of people who think they're very clever think they can just do a licence. But it's what's called a sham tenancy. You can't produce a licence unless you provide a service. All right? Does that answer your question? Whew. Right, that's your limit. I'm joking. You're going to have entry onto the database. So that will have your gas safety certificate, your EICR, I always hesitate because it spells Eric in a different order. All these different requirements, Legionella's risk assessment, all the rest of it, you will have to have on this database. If you don't, usual fines. We can do this for you because, after all, we hold all this information. All right? There will be fees from the government for the operation of it. Again, civil penalties, rent repayment orders, ban on marketing. They even want to publish your name and address. I don't know how that's going to work under data protection. But we can charge you to do this. And by God, we will. But we can do it cheaply and very quickly. Has anyone heard of AWAB's law? You have? That poor little 5-year-old kid who died because of mould and mildew in a property. Can I point out this was social housing? These are the properties that are really infested. Most landlords look after their properties, don't you? Okay? They look after them. We don't have problems very often, and when we do, we get them fixed. I'll tell you a very quick story about this. I once rented a flat in Lock's Wharf on the Isle of Dogs to a lovely lady who phoned me up. It was a new flat. She said, I've got mould all over the bedroom wall. What? So I went round there. Guess what? There was mould. So I used to genuinely carry Detox mould and mildew remover with me. So, all gone. 2 days later, it's back. So I said, look, I'm really sorry about this. I'm going to go and hire you a dehumidifier, because I'm that kind of guy. So I went to B&Q, got a dehumidifier, stuck it in the flat, said, can I go back tomorrow and just have a look at it? She said, yeah, of course you can. Went round there, and it was full. I thought, this is madness. Opened the second bedroom door, and there were 3 clothes horses of sopping wet washing and a closed window. And this is, honestly, I'm not making this up. I said to her, there's no ventilation. Why don't you open the window? She said, oh, it's London, I'm scared of burglars. You're on the 4th floor. Who causes most damp and mildew problems? Tenants, lack of ventilation. So make sure, and we've got a leaflet on our website about how to prevent damp and mould. Give it to them. It's all part of the defence when they complain. However, AWAB's law says if a tenant complains about damp, you need to commission a specialist report within 7 days, then you've got 14 days to fix the problem. Now, I don't know if you've ever come across damp. Bloody hard to find out where it's coming from, but you have to be aware of this because it's a hot topic at the moment. The HHSRS, the safety rating system, please, 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 if you do nothing else over the weekend, go and have a look at it on the government website. Teach yourselves about Category 1, Category 2 hazards. Same as with Legionellas, you can do your own risk assessment. How many people do you reckon have died of Legionella's disease in tenanted properties in the last few years? 3. And in each case, they'd been to Spain. So I would think about banning Spain. Anyway, you need to just familiarise yourself with these because it is important, and we have a duty to look after tenants the same way we do look after our landlords. So one thing you should know is trading standards investigatory powers have expanded massively. At the moment where I live, the local trading standards officer said to me, I don't give a toss about stickers in windows, but Newham trading standards can go to Cornwall and start finding agents. Okay, they can go anywhere. They can seek information from any party, they can enter a premises without a warrant, and they can investigate the flat. So you should just be aware of that, not that you guys are doing anything wrong. So agents' fees, there is going to be a change to our business model. It's not going to be onerous, but I spoke to a lady the other day and I said to her, do you know, if the Renters' Rights Bill was in now, you'd have been fined 40 grand. And she said, oh my God, that's really scary. I said, why don't you use a managing agent? Too expensive. We're 40 grand cheaper than you are. So we are going to change our terms of business. We haven't decided how that's going to look yet, but you will be the first to know. When is this going to come in? Well, I was talking to government yesterday. If it gets royal assent before the 22nd of July, when the House goes on their summer holidays, it will come in October, November. If it doesn't, it won't come until January, February. Not long, is it? I should update this. The committee stage is just finished. Once it comes in, Section 21 will be abolished for all tenancies immediately, apart from where it's already been served. All fixed terms in your tenancy agreement will end immediately. And this is true. It actually says this in government guidance. Everything else will be implemented when ready. On the dot. So how long is it going to take them to build these databases? Who knows? We don't know. But Matthew Penny Cook wants this in place in the summer, as in royal assent. I don't really think it's likely, but it might. I hope it does. Let's just get it done. Finally, almost, the great landlord sell-off is a lie. Okay? They aren't selling. And I promise you, there is a changing profile. People who are selling up, we just sell to other investors. The profile of an investor is changing. They're getting younger. Okay, we've got a lot of young people. We've got some people, you know, who rent a property in London themselves, then go buy a couple of properties in Sunderland and rent them out as an investment. So the profile's changing. 11% of landlords put their property on the market for sale, but 40% of them put them back on for lettings because they don't get what they think they're worth. We don't have more stock than we expected because landlords really aren't selling. We talked a lot yesterday about yields. I've got a friend who's a fireman, and he came into a lot of money and went out and bought some investment properties. and he's since become the Martin Lewis of rental properties. And I taught him how to calculate the yield. And now he's saying to me, Eric, my yield's gone down. I'm not happy. I'm sorry to hear that, Nigel. How much did you buy that house for? 250 grand. And what's it worth now? 500,000. You poor bastard. You know, no wonder times are tough. So look at capital growth as well as yield. And as I've said before, self-managing may prove very expensive. Is anyone going to still continue self-managing? Okay, well done. That's 2 of you. Be careful, that's all I'll say. And if you do want to self-manage, I absolutely respect that. It'll become a much more labour-intensive job, but still talk to the office about rent and legal protection, just to cover yourself. I do worry. So finally, if you've got any questions, please let me know. Any questions, anyone?
If you do employ an agent and something goes wrong, are they liable or are you still liable as the landlord?
It depends who was in the wrong. So we could well be liable. That's why we've got professional indemnity insurance, which you won't have. If it's something you've done wrong, you'll be liable. But ultimately, it'll be down to the local housing authority to determine that. Okay? If you use us, you won't get fined. How's that? How's that?
Can you just clarify a bit about the service department?
Service departments, if they're... Yeah, I mean, look, it's a very good question. The trouble is, it depends on your tenancy agreement. Okay, I'd need to see a tenancy agreement. If it is an AST or could be construed as one, yes. But if you're using it and actually providing that service and it's a licence, no.
So if the sale's achieved in July, you said the effective date may be October or November, so section 21,
Last 6 months.
can that still be applied as October?
Yes. Irrespective of when the law becomes enacted, your tenancy agreement that has had a Section 21 served before enactment will have a lifespan of 6 months. Does that answer your question?
But you can't serve it after,
No.
after the sale,
Not after it becomes enacted.
which would be July or
Well, we don't know yet. Oh, I see what you mean. I mean, when royal assent doesn't count. It's only when it's enacted. That's a really good question, thanks.
You said in terms of the almost like a minimum length to the tenancy will become 3 months.
Yeah.
So I guess one of the implications then is that landlords will need to kind of increase potentially the rent over the fact that they can be much less efficient. Whereas obviously you can kind of smooth that over a long period.
It's a good point. It wasn't me who said it. The question was, if a tenant can move out after 2-3 months, can they increase the rent to even out the cost of churn? The answer to that question is you can charge what you like. It's your flat, your house. The reality is they don't. So this was the question asked of me a great deal when we introduced the Scottish legislation. People don't move. They've got to find another deposit. They've got to pay for Sky TV again. They've got to pay for removals. They just don't. But you are right, and yes, you can. Does that answer your question?
On the landlord's register that they are wanting to they also want to implement a number of evictions that you carried out.
What they want and what they're going to do are two different things.
But would you, if they did do that, could you then, would it be, oh, you just evicted X number, or under what grounds you evicted?
Yeah, but don't forget, evictions will only be linked to fault or because you need possession of the property, so that's not going to happen. When they announced that originally, it was about Section 21 notices. What percentage of properties do you think we get possession of using Section 21? Any guesses? 6%. 6%. So it's hardly the issue that the S Club people make it to be. 6% of people are actually evicted. Anyone else for any more? Yes, ma'am. No. Only properties that are currently within the 1988 Housing Act. Commercialism, that's the 1957 Act, if I remember correctly. Is that right? I could say anything, couldn't I? Yes, sir.
Are there going to be any distinctions in types of tenancies? For example, I never mentioned just there commercial, forget that for a second. Residential, HMO, student. Are there different practicing this?
No. No. It's one brush. Anything that's currently a Housing Act tenancy of the 1988 Housing Act or 2004 Housing Act will be affected. There's no differentiation. Right, I think I've bored you enough. So thank you very much for your time.
How are we all doing this evening? How are we actually doing after that? All jumping for joy? So I'm here, as Eric probably pointed out to you, to provide you the solution. What are we doing to make sure that you guys are going to continue to get a return on your investment? That's what you're probably thinking, right? You're in this not for charity, you're in this because you want an income out your property. So we need to talk to you about what we're doing to support to make sure you will continue to get a return on your investment, because that's the most important thing. Now, my name's Lucy. I work for HomeLet, which is the biggest provider of tenant referencing and rent guarantee products in the UK. So it's quite fitting we work with the Property Franchise Group. Now, before we dive into the presentation, which is going to look at some of the elements of what we're going to be doing to protect you moving forward, I just want to start with something to get you thinking, okay? Now, I'll talk about a story, something that happened when we went into lockdown, when furlough was around, okay? So our rent guarantee book is massive. It extends to about £1.5 billion in annualised rent. So it's not a small kettle of fish, okay? When the went into lockdown and furlough was around, our insurer had a massive influx of claims. Huge. Now, why do you think that was? Okay. So we've had a couple of thoughts there. Tenants not being able to afford to pay their rent. It was actually to do with the media, shockingly enough. So there was these great things called mortgage holidays. Some of them might take advantage, some of us might have not. But how did the media portray that to tenants? Well, they portrayed to tenants in a way, you can have a 3-month rental holiday. And guess what? Every tenant was on that blower quicker than you can say, you know, lockdown. And what a lot of the time we found is that they were trying their luck. They were sold this narrative in a certain way that made them feel empowered and think, oh, I can get a 3 months rental holiday, so they tried their luck. When we actually questioned them on it, because we knew the government actually enforced a deferral agreement or, you know, a kind of a revised rent schedule to pay back the debt, what did tenants do most of the time? Oh, actually, I don't need that. Don't worry about it. I was just seeing if I could try. Now, the reason that I like to start with that is to talk about the power of the media and the power of the narrative that will go to your tenants, okay? You might have had tenants in situ for a long period of time and you trust them. Why shouldn't you? But what we are seeing is behaviours, people act differently when they are given an opportunity to try something. And so there's two elements of what we need to take into consideration with the Renters' Rights Bill. We need to consider not only if you've got a new tenant moving in, making sure we're protecting you accordingly, but for example, if people are going to chance, then you guys are going to have ultimately the protection as well to make sure that you're confident moving forward, okay? So, who are HomeLet? Well, I've already said we're the biggest in the UK. We do about 1 million references a year. So that gives you an idea of our sheer volume and size. And as I said, our rent guarantee book is extensive. So it was only appropriate that we have partnered with CJ Hole and the Property Franchise Group. Why? Because we want to look at things innovatively. We want to look at things differently. We can't apply the same principles of how we due diligence on tenants that we have for the last 30 years. Society has evolved massively, and so we need to make sure that when we're doing these types of things, we're doing something given the threats that we see out there, okay? Now, that's quite a strong word there, fraud. Who thinks about fraudulent referencing? Keep anybody up at night? Does for me. Fake bank statements. So you guys who are using CJ Hole, you don't need to worry about this because they'll do your due diligence for you. But it's interesting for you guys to have a look at what we are fighting against now, okay? So I'm going to give you an example. Say that I'm dealing with a tenant. That tenant has been in a rental property, one of your lovely rental properties for the last 6 years with their family. They've been an absolutely sublime tenant. However, that rent needs to go up, shockingly, to pay for your costs. So they try and put the rent up, that tenant can't afford it. So what do? You serve a Section 21 to get a replacement tenant. That tenant looks out over the open market and says, I can't afford that rent given how much everything's gone up. And I need to put a roof over my family's head. So ultimately, out of desperation, I'm going to have to make a decision. So what do? Well, I go onto a lovely thing called Google. I type in fraudulent bank statements, and I'll see what comes up. I've got a list here, got quite a few on there. You'll see Etsy's on here, which I thought was a craft company, which is always interesting. There's one called Template Lab that we know very well. It's an American site. It crops up under loads of different URLs. They have American bank statements and they have English, okay? As a tenant, all I need to do is scroll down, find the bank statement that's relevant to me, click into it. Now, I know this bank statement because I actually use this account. I don't have to put any of my information in, just literally download it. I've not been doing online shopping before you judge me. And I just export it into Word, start editing, remove the logo, and bang, I can start putting my false information in. Does that shock? I know you've just had a crash course in fraud, by the way, which I know you all loved, but does that shock anybody? This is what we're dealing with at the moment. And I kind of consider myself a bit of a fraud specialist, but I'm seeing bank statements at the moment that I can't even pick up if they're fraudulent or not, okay? So there's two elements, again, that what we need to make sure we're doing to protect you. And this is why the partnership with ourselves and CJ Hole is so important. This is why, together, we need to kind of navigate these next steps to make sure that we keep them safe and we keep you guys safe. So again, you've got confidence to remain in this market, okay? Because it is a profitable one. We just need to do the right things to make sure that you guys are confident, again, you're going to get a return on your investment, okay? So, what is our solution? Well, again, CJ Hole can benefit from the fact that we actually offer an AI portal in our referencing process. Not a cheap thing, AI. However, straight away, if we drag and drop a document that the tenant's provided into our system, we can see if it's been modified in any way from the original document. Had one last week, actually, very creative. Somebody said they had 6,500 in their bank account. Guess how much they had? 12p. Got to give it to them, right? But this, again, this shows the level of our referencing. And just to kind of add an extra layer to that, we're actually the first provider on the market that uses the tenant's full credit file, okay? If we think about the purpose of referencing and how it's been done for the last 30 years, you kind of do a rough credit search, you go to their employee, you say, do you still work there, X, Y, Z? The problem is there's a high risk of fraud in that process because I could think I'm speaking to Sally from HR and I'm speaking to Susan, the tenant's best friend. We need to align the way that we do referencing. We need to innovate it to make sure we're utilising data, things like working with Experian, who we are partners with. And that allows us to have a more granular level detailed view on tenants, where not only can we see what they can, what's going into their bank account on a monthly basis, but we can actually see how much credit that they're signed up to. Doesn't matter if they're earning 35 grand, if that's all going out on finance, you know, loans, whatever, they've not got the net affordability to afford your rent, which is the most important obligation that we need to ensure that they are meeting, okay? Again, no other referencing provider on the market has these means at their fingertips, but that is the reason that we partner with CJ Whole partner with us, because we have the ability to, we have the resources to be able to facilitate this for you, okay? And again, they probably don't shout about it enough, but it's important that you guys know it, because this is a step above, a grade above the competitors that are out there. Now, Eric's beautifully touched upon the Renters' Rights Bill. I don't think I'm going to do him justice, but I will try. And we're just going to hone in on a couple of areas which are going to be really important when it comes to rent and how things like rent arrears are going to be impacted, okay? So we know that the period of arrears before legal action can be taken is going to go from 2 to 3 months. We know once that 3-month period is done, once you actually apply a notice, you have to give 4 weeks notice at that point, okay? So technically, a tenant can be in situ for 4 months before you can even do anything. Again, Eric touched upon it earlier. The scary thought is a new tenant, you could go to put them in the property, you could execute the tenancy agreement, they could turn up at the branch and they could say, hand over the keys. You could say they haven't paid the first month's rent yet, and you would still have to hand over those keys, and there's nothing you can do for 4 months. Now, we are telling you this not to scare you. We're telling you this because you deserve to know what the risks are going to be moving into this new world. But the reason that CJ Holt want to do events like this to tell you, so you can make a considered decision about how you are going to be supported moving forward, which is, if you don't have a managing agent, my advice, get one. At minimum, get a level of rent protection. Even if it's the next 18 months, while case law starts to sort itself out and when we can actually see trends in court, make sure that you are supported in this eventuality. And CJ Whole are going to offer a service, which we're going to go through in a second, which we work with them to make sure we're delivering the best in class in regards to some level of protection. Okay? Now, we also know Section 21s are not going to be used. Eric's rightly said it's not a massive volume that we actually evict off the back of Section 21s, but we use it as a backup. So if, for example, there is something that we want to evict on, Section 8 grounds, it's discretionary, it's not mandatory, we will utilise a Section 21 where possible. We won't be able to do that moving forward. We haven't got that safety net, okay? Now, how is that relevant to this situation? So if we actually look at 2024 as a whole, how long did it take to evict tenants? We've already told you about how big our rent guarantee book is. So based on the behaviours within that book, that gives you a very kind of good mean about what's going on in the industry, because we work with everybody in the UK, okay? So it took, on average, about 7.5 months for the first point of arrears to actually getting vacant possession of the property. That was the whole of 2024, okay? That actually grew in the last 6 months of 2024 to 8.5 months, okay? So what we need to consider is, in today's world, it will probably take 8.5 months at the point that you actually applied for possession at a court, you get a court date and you get possession granted, okay? Now let's think of it in a new world where you have to wait 4 months before you can do anything. We're moving over a 12-month period at this point. Again, this is not to scare you, it's to talk to you about what it could be to come and make sure you understand the rationale as to why we ultimately want to give you a level of support moving forward. There is 2 elements of this protection. There's the referencing, putting the right tenant in situ, and then unfortunately, if something does happen, which is most commonly relationship breakdown or loss of job, you are adequately protected in that eventuality, okay? Let's look at a claims example. So we had a claim that went through, it was last year, and the tenant was in basically 2 months of arrears, okay? We applied for a possession order, and we actually got a court date quite quickly on this occasion. It was actually on October the 28th, off memory. Now, the tenant turned up to that court date, that possession hearing, and said, I've not paid my rent, but I've got a defence, but I haven't had a chance to prepare my defence yet to Mr. Judge. What do you think happened in that scenario? They adjourned the case. They said every tenant has the right to prepare their defence. When do we think the next court date was appointed? The end of June this year. Okay? So even without complications, it's quite a long span to get a court date. If there are complications like that, it's going to be even longer. And this is the type of figures that you could be looking to lose. So when you actually relate that back into a management fee, into a management fee with a level of rent protection in it, it doesn't look so much because this is a much, much higher risk. Okay. Now, we're going to go for the features of the rent guarantee policy that HomeLet offer, okay? And CCJ Whole, you will benefit from this being an extension of their service. Before I go into the specifics of this, I just want to cover 2 areas. Number 1, Eric mentioned pet damage insurance. We have a product that will come to market where the landlord will be the policyholder and give you protection, okay? We will release information about that as the bill goes through royal assent, because we just need to fine-tune the fundamentals of the policy. That will be in place and CJ Whole will be able to provide it to you, okay? Second thing, how many people have insurance with Direct Line? I love that no one put their hand up, even for like comedy reasons. You look at a company like Direct Line, they've got plastered all over, you know, marketing campaigns. We offer rent guarantee for 15, 16, 17 quid a month. Looks great, right? You think Direct Line are a trusted brand, brilliant, I'll go with them. Did you know with Direct Line, they won't start paying out any rent arrears until a valid Section 8 has been served at your expense. So at the moment, that's 2 months. That's me going to 3 months. But if a valid Section 8, again, at your expense, which you'll have to pay for a solicitor to do so, cannot be done, that invalidates the claim. So when we look at these providers out there that look cheap, look too good to be true, they probably are. When we went to partner with the Property Franchise Group and CJ Whole, they went through our policy rigorously because they wanted to know that if there was an official partnership with them, it was going to be a policy that worked, okay? And that's what we need it to do. So there's 2 elements of this policy. It covers the rent protection, the rent guarantee, so it reimburses the contracted rent while we're looking to get vacant possession of the property back. That's number 1. The second element of the cover is the legal side, okay? So if we can use the Direct Line example, if you made a claim with Direct Line tomorrow, what would happen is you would get sent to a third-party legal company that you have no relationship with, and all you would do is chase that legal company for updates. No personal touch, again, no invested interest in you. What we do here at HomeLet is we have an in-house litigation team, okay? And all we do day in, day out is property law. So imagine the case law experience that we have. We're not like a solicitor down the road that does a bit of property law, family law, environmental law. We are specialised in one area, and that means that you guys are going to benefit from that. And again, by the partnership that we have with CJ Whole and Property Franchise Group, we have a commercial invested interest to make sure this product and this legal service delivers in the way that it's depicted on here and how we promise, okay? So the rent protection covers up to 15 months of rent arrears or until vacant possession, whichever is sooner. We cover up to 100,000 in legal, but again, we have in-house litigation team that deal with it. So you don't need to go to a solicitor and organise it and then claim back that money. When CJ Whole ring you and say, unfortunately, worst case scenarios happen, the tenant has fallen in rent arrears, they will follow up that statement with, but don't worry, as part of your service, we will reimburse you, so you'll still get your rent on a monthly basis, And we will liaise with Homes Let litigation team to make sure that we've got the best possible chance of actually getting vacant possession as soon as possible. So you guys can sleep at night. All sound good? Good. I'll just pop this down now. No. So if, for example, people on universal credits, if they're students, any one of them, we've got actually an arrangement with CSJ Hull that any tenants in situ at the moment that we will, on a one-time basis, offer a policy on inception as long as they're not in arrears. So take it while you can, because moving forward, it will have to be that they're acceptably referenced. So you've got a massive opportunity here.
So if they're professional tenants to start with and then become benefits tenants, it won't
No. So it might be on renewal that we would ask for an additional due diligence, but it wouldn't null and void the policy, no. And at the moment, the policy covers overstay of Section 21. So Eric's already made reference to, as soon as the Renters' Rights Bill comes in, Section 21 will not be a thing. But while it is now, and if the tenant, you do serve notice on the tenant to get the property back, tenant doesn't vacate, you can claim on the legal side of our policy. So that is something that's enforceable at the moment, okay? Now, just to conclude, a lovely picture of our CEO, Andy Housestead. I'm not going to try and do an impression of him. I won't do him justice on what he says here. But what I just want to point out is the size of us and the fact that we partner with 5,000 letting agents. That's not a small number when you actually think of the pool of letting agents within this industry. The reason that we partner with them is because, again, we don't just do things the way they've always done before. We understand that things are evolving. We understand the industry is evolving. And we need to make sure that we are innovative to make sure we're going to deliver you the best service that we can. And again, the most important thing, and I keep banging my head against a brick wall saying this, it's our responsibility to give you guys the consumer confidence that this is a viable investment. And it is, and it will continue to be. We've just got to make sure that you take our advice in protecting yourself in two ways, doing due diligence on the tenant, but if worst case scenario happens, you've got something to fall back on, okay? Has anybody got any questions? I will be here after, so if you're embarrassed and you don't want to shout out now, you can ask me after. No? Amazing. Thanks all.
I've got direct line insurance. I lied. I just want to, and I'll just cover off on that. I deal with all the compliance complaints, and there are certain providers, not just Direct Line, but there's a lot of rent and legal protection providers who don't pay out. They employ loss adjusters whose sole mission in life, and you'll agree this, is not to pay out. Anything that says Das Legal, don't touch. So anyway, I just wanted to say thank you very much for putting up with this. I know it can be a bit painful, but there's quite a few of my CJ Hull colleagues here. Claire, wave. Mr. Prosser, wave. And all the rest of them over there, so please go and talk to them. If you're a landlord without rent and legal protection, you know, we're not making money out of this, we're trying to sell it to you to protect you. Please, please, please have a think about it. We'll be around for a little while. I'll be the one with a pint of beer. Just come and talk to us. And it's been lovely meeting you. And can I just say thanks for the great questions? Well, most of you. All right, have a safe trip home, everyone.